Hello student, welcome to BGS011. Today I am going to discuss this topic, Patriarchy in Law Part 2. While debating this particular topic, one has to also see, and which I talked about previously while understanding the concept of patriarchy, we have seen that how the other marginal categories and their experiences arise from multiple intersectional forms of the dominance and oppression. For instance, that LGBTQ and so on. So in this particular lecture, the objective is to know about the key historical movements from the constitutional history of India and how a sort of making of the constitutional rights for the people came into existence. At the same time, how this debate of formal and substantial equality is there on the and also on the other hand, this whole debate of the directive principles and fundamental rights which we have. So few of the example and few fundamental rights and directive principle I would be mentioning also here. And therefore, it will help us to understand the ways in which that, the methods, constitutional methods that organize and, sort of address the issue of the patriarchy through this discourse. Or one would call it that, how, patriarchy in law is challenged through this, constitutional rights, which historically the efforts have been given by the people who made the constitution. One of the very known historians, Satish Sabharwal, who has done sort of larger work on the Constitution of India. Now, if you look at his work, he in one of his article, he pointed out that the tumbler can be, and I quote, the tumbler can be seen to be both half and full and half empty, unquote. I would, recommend to all of you to read this very interesting book, Civilization, Constitution, Democracy. This is a chapter, of course, which is written by him in one of the book, India's Living Constitution, Ideas, Practices and Controversies, which is, edited by Zoya Hassan, E. Sridharan and R. Sudarshan. This got published in 2005 by Anthem Press, London. And this particular, this thing which I talked about, you can always go and revisit his article to understand more. And what he draws, in fact, is by stating this, is that probably he's trying to argue that, there are two kinds of ways in which one can think about it, that it deeply evolves us, also alterations are there, then constitution has been able to make the sort of governance in the post-colonial context in relation to the culture. And since the idea of the constitution and sort of, constitutionality, working constitutionality, culture, it considers, consequently and conceptually and consequently different, which two position he talks about. One of the position where he specifically says that rather sort of narrowing on the constitutional text and much separated from the politics and social culture within which operates. And then the second position which he's trying to argue is that concern besides the text also is with the context and the ways in which it evolved us, what is the purpose of that, and the text also locating and operating. So in one way is that, an immediate consequence of this is to accord, essential projects with the objectives, and one can further go and engage with this. So what is needed therefore is to continue having an ongoing engagement at the individual governmental level, and then whole debate which emerge again is the moral ethical sort of sight, or a vision of the constitutional project towards sort of try to find out the constitutional choices and the alternatives within that spaces. In fact, Sabharwal also comments that particularly that it might be a possibility that these kinds of aspect of Indian constitution, which is a working one, where he again, sort of arguing that this project of constitutional making is again, redefining, undoing certain kind of otherwise. And one would see that these culture practices in the society, which also includes, say for instance, when one is talking about marginal communities, the issues, especially we talk about the Dalits and the untouchability. Then we do talk about the gender question, woman question, and we do talk about the patriarchy also, which is unfinished project partly. So in that particular, then if we contextualize this, the working of the constitution, of course it's again been a project which is ongoing and dealing with the question of the patriarchy, and therefore you could see that the majority of the laws amendment which came into existence back and forth after India got independence. And one must in fact try to sort of locate this at two levels, is the constitutional debates that sort of cultivated into explicit texts of the fundamental rights, which and directive principle of the state policy. And B is that the ways in which the judiciary is responding to it, or the ways in which judiciary is engaging into interpreting those texts with sort of interest and disinterest of gender or woman also category. So one has to then therefore engage, because as we see that the directive principle, fundamental rights, the ways in which judiciary is engaging and pronouncing the judgments, and therefore it's very important to understand the constitutional assembly, the historical location which one is talking about, and the constitution around the period of the 3 years between the December 1946 and to December 1949, because this is particularly a period after the partition of the India, which one has to see that how the constitution makers were engaging into making of the constitution. And therefore the assembly was held, and the 229 members who were sort of engaging those elected indirectly by the 12 provisional assemblies, and you would see that 20 of them and 70 of them nominated to the representative of the 29 princely state. And then you could see that how the women members were there. I mean, it's not a huge number, but it's around 15 of them were there. At the same time, you would see that it was dominated by the upper caste class women coming from particular religion, and then how it was engaging into that. And you could see that very few of them were there, like Muthulakshmi from again South, Dakshayani Velaythan, then Begum A. Rasool and Annie. These are again coming from sort of Dalit Muslim Christian background, and they were part of those committees. So and I would in fact recommend to you that there are fantastic books which are available, which you can always explore. And one of the ways in which it is engaging us to have a sort of debate, to engage with this, again also the reservation debates which we do talk about in the contemporary context. You can always visit this fantastic book by Maitri Chaudhary. Then also, one of the very fascinating article Mary John wrote in APW dealing with this debate historically, and how women have taken up their issues. So you could see that, barely that those women who were there, and you can always see the work of, Ishita Srivastava also, and where she argues that there are 15 women who helped to draft the Indian Constitution, unquote. And therefore secondly, that the Constitution through this, sort of, fundamental rights and directive principle of the state policy, it's trying to again putting an effort which one would call it that empowers the people to change their lives. So people's, are there to bring out a change in laws, and then also that then how that autonomy power is there, which is engaging, and particularly in the context of voting rights. They are the one who are going to go and elect the candidate who would be the political representation, who would sort of represent them in the parliament in order to put forward their interest. And you would see that around that time it was 28 legislature. So since the the legislative sort of outcome was there, it was all depend on the majoritarian interest. And one would see that how those debates in fact emerge, and you could see that the minority interest again is which is there, which is again been questioned as a sort of engaging into this debate. Now, these kind of legislative powers, therefore, and the Constitution, which empowers the people through approaching this legislation, courts, and the review of this kind of legislative, then whether it might be legislative, it might be administrative, and so on. But then one would see that how fundamental rights in fact gives us that kind of a platform. Now these the judicial review, the power, the courts, which one also engages with. Now what is unique about the fundamental rights, which one has to understand, the Constitutional provides that are there and enforceable against the state through judicial pronouncing. Like for instance, if some if any how violates and fundamental rights, to the extent to such violation, such law shall be void. And you would see that how one is further getting into this debate of the directive principle of the state policy that is relatively non-enforceable against the state. And you would see that the ways in which the fundamental rights are there, and then how in the country that the governance took place. Beside this, this debate demanding the legislative intervention, the statutory framework is also there. And you would see that the whole engagement of the Supreme Court, High Court, how it is significantly doing the intervention when it comes to the constitutional or legal implementation precisely to determine such kind of forms, primarily following the fundamental rights and directive principle of the state policies. And you would see that how then eventually that judicial proceedings are taking place, and sort of one would call it challenging the laws itself. I think that one also needs to understand, you know, particularly this debate in order to this understand, and I would in fact recommend you to read very interesting books, particularly by Gautam Bhatia, the most recent work also, the ways in which it is engaging. Just to make you understand the few examples, I think the fundamental rights. Now, Article 14 is something which one has to look into, and I will state few fundamental rights here. Now, equality before law. What it says is that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 15 also say A, prohibition of the discrimination on the grounds of the religion, race, caste, sex, or place of birth, and within that the state, shall not discriminate against any citizen on grounds only of the religion, race, caste, sex, and place of birth or any of them. Article 15.2, in fact, no citizen shall, on grounds of only of the religion or race or caste, sex, place of birth, or any of them subject to any disability. And then one would see the liability restrictions on the condition with regard to A, access to shops, publics, restaurant, hotel, place of public entertainment, and B is that, or B, the use of the wells, tanks, bedding hearths, roads, and places of public resort maintained within or partly out of the state, funds, or dedicated to the use of the general public. Now, Article 15.3 also stating that nothing in this article shall prevent the state from making any special provision for women and children. And Article 16 also is there, which one can take and cite the example of all these things. So as I mentioned to you, the Article 15, Article 16 also talks about it, the equality of the opportunity in the matters of the public employment. And then no citizen shall, on the grounds of the religion, race, caste, sex, decent place of birth, reside, or any of them be ineligible for or discriminated against the respect of any employment or office under the state. You would also see that nothing in this article should prevent the state from making any provision for the reservation of the appointments or the post in favor of any backward class of the citizen, which in the opinion of the state is not adequately represented in the services under the state. And one has to also understand the directive principles of the state policy, for instance, the Article 39. Certain principles of the policy to be followed by the state. The state shall, in particular, directs its policy toward securing that the citizen, men and women, equally have the right to adequate means of livelihood, that there is an equal pay for equal work for both men and women, that the length and the strength of the workers, men and women, and tender age of children are not abused, and that citizens are not forced by economic necessity to sort of enter avocations unsuited to their age or strength. And further you would see that Article 42, provision for just human condition of the work and maternity relief. The state shall make provision for securing just and human condition of the work for maternity relief. Now, it's been important to understand this debate, and I will cite some of the example further in order to understand, fundamental rights and directive principles of the state policy. So let me conclude by saying this, that in this lecture the effort was that how this constitutional provision and the rights, and that historically the effort of the constitution maker was that to bring out sort of equality through the legal intervention, and where one would see that they are trying to balance this whole idea of gender equality through this kind of judicial proceedings further, and through in the constitution of the India. So to conclude this debate, what I'm trying to argue is that how historically the constitution debate which emerged, and the maker of the constitution in fact taken into consideration that how law can be which is there in patriarchal nature can be challenged through this discourse by bringing equal rights of all. Thank you.